Okay, I think it's time to begin. I will be logging some people on, so please bear with me. Welcome to PIBC CPL webinar number 6, Ethics and Professional Conduct. My name is Sophie King. I'm the Manager of Professional Learning at PIBC. And again, welcome to this very important webinar. This webinar is originating from the city of Vancouver, which is founded on the traditional territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. Other presenters may be presenting from other areas, and we respectfully acknowledge those traditional territories. Our speakers today are Eric Vance, Principal, Eric Vance and Associates, Chi Kai, Senior Planner at the Pooni Group, and James Stiver, Director of Planning and Building with the City of Maple Ridge. All three of our speakers, in addition to their day job, are also PIBC Professional Conduct Review Committee members, and they have a lot of experience behind them. So on that note, we will begin our presentation. I will ask our speakers to please turn on their cameras and their webcams. Sorry, their cameras and their microphones. Hi, Chi. Hi, Eric. And there's James. Okay, I'll let you begin your presentations.
Thanks, Sophie. And hi to everyone joining us over your lunch hour. So over the next hour and a half, Eric, James, and I will give you a crash course on how to be ethical and professional in your planning roles. So our presentation this afternoon includes, what defines being a professional, explaining the importance of ethics in the planning profession, give you an overview of the PIBC Code of Ethics and Professional Conduct, outline the PIBC complaints process, talk through a few real-world case studies, and end with Q&A. So feel free to pop your questions into the chat as we go along. So what distinguishes a professional planner from just someone who does planning? If you're working in planning, why go through the process of actually becoming a registered professional planner? Well, professional is defined by following attributes. So as a professional planners, we possess specialized knowledge and skills to integrate technical matters with complex social and economic needs, guiding the development of cities and regions in ways that serve the interests of the current residents and future generations. We get formal recognition. We get some letters after our name. So the RPP designation is a formal recognition for professional planners in Canada. Achievement of this designation is regulated by the Provincial Institute. So in BC, it's the PIBC, and overseen by the Professional Standards Board on behalf of the Canadian Institute of Planners. So to achieve the RPP designation, planners are required to have a combination of education, work experience, mentorship, passing of a professional exam, and ongoing continuous learning. So PIBC, we're governed by a set of bylaws that provides the framework for the Institute, including requiring a code of ethics and professional conduct and defining the professional conduct review process, both of which we'll go into on this webinar. And finally, the code of ethics and professional conduct guides professional conduct and promotes public trust, ensures accountability, upholds professional standards, and protects the public. So having a code helps to distinguish a professional body from the rest. So as planners, we are constantly reminded that we are to serve the public interest, but what exactly is the public interest? So there's actually no one definition for public interest. Instead, it's a collection of considerations that need to be balanced whenever we make decisions. For candidate members who are studying for your exam right now, the PSB has an entire module on the public interest, and it's summarized on this slide. I won't read every single point. So how you serve the public interest may vary slightly depending on if you're working in the public sector, private sector, not-for-profit. But ultimately, it's about looking after the welfare or collective well-being of a community as opposed to prioritizing individual or private interests. So why is ethics important for the planning profession? So following a common code allows professional planners who may come from differing backgrounds to be guided by a consistent standard. So like with other professions, reputation is critical, especially with when planners are making recommendations to elected officials, providing guidance to clients, or sharing with the public how their communities are going to grow and change into the future. Professional planners must earn the trust of the communities that they work in, and that is done through a combination of education, understanding the public interest, and conducting their work within the code. So even then, it's often a tough sell for communities to accept new neighborhood plans and policies that bring a considerable amount of change to their community. But without the code and the professional designation, it would be even more difficult for planners to carry out the meaningful work that we do. And I will now turn it over to James.
Great, thanks, Chi-Chi. We can now dive a little deeper into the Code of Ethics and Code of Professional Conduct. So they're two separate elements. So the National Code of Ethics and the Code of Conduct, all planning institutes must be consistent with and follow. PIBC has its own, but it has to be consistent with the national standard. The code forms the basis of our practice in terms of expectations and obligations to the profession and to ourselves as professionals. So on the Code of Ethics side, it's a mechanism that ensures that we are using our skill set properly and we're benefiting the people we're serving, we're benefiting our communities and people on a broader sense. And Chi-Chi touched on the public interest a minute ago. On the conduct side of the equation, it's around how we act as professionals, how we're perceived by the public and by other professionals. It is a national standard as well, and it provides consistency across the country related to how we conduct ourselves, and we've all committed to following that in our practice. So on the diving a little deeper into the ethics side, there are two key elements that we must keep in mind. It's around competency and integrity. Competency means being competent in your area of practice, staying within your area of expertise, and not promoting yourself as being knowledgeable in other areas, but also being successful in your implementation of your competencies and keeping up to date. Having integrity is about being responsible to the profession, to your employers, to your clients, to the public interest, again, comes up, being honest and fair and thoughtful, using your judgment in an evidence-based manner, and exercising that judgment independently, and taking on the responsibility of that. So in order to comply with these lofty standards, in your capacity as a professional planner, it's your responsibility to practice sustainable planning and value the natural and human environments, acknowledging the effects of your decision over the long term, and recognizing that there are short, medium, and long-term impacts, but your actions can be long-lasting and far-reaching. It's important to balance the local needs versus individual interests, but also the broader community. And again, the public interest piece comes into play over the broader impact. And the intention is it's well beyond the immediate impact of your decision, recognizing that there's lasting results of your actions. And it's important to always strive to improve, be curious, be knowledgeable. The continuous professional learning program is essential to helping us stay on top of new and emerging practice and knowledge. But also we have an obligation to the public around facilitating meaningful public participation and what that means to decisions going forward. So the professional conduct side of the equation, we also have a responsibility, again, to the public interest and recognizing that our actions can have impact on real people. We have responsibilities to our employers, and I know we're going to dive into this a little deeper with some of the case studies, and also clients, and sometimes that starts to butt up against what we see as potential conflicts of ethics and conflicts of our responsibilities of conduct. But we also have a responsibility to the profession and other members of our profession. And again, we'll dive into this in a few minutes a little deeper, but there's an optic component of that as well that we have to keep in mind. So the professional conduct sets out the way that we act essentially as professionals and carry out our work. So on the conflict of interest side of the equation, I think it's inevitable. Having worked in the profession for many years, it's inevitable that conflicts will come up. Sometimes they'll be very subtle, and sometimes they'll be more obvious. This is what we're going to explore a little bit with our case studies today. Of course, conflicts will occur regardless of your capacity, whether you're working in the public sector or private sector. Sometimes conflict can make your judgment unreliable, depending on the depth of it and the situation you might find yourself in. And again, just to echo, we have a responsibility to act independently as professionals and not be influenced by outside forces, but also the perception of influence is also just as important to keep in mind. And when we do find ourselves in these situations, it's really important to disclose that conflict or the potential for conflict with your employer, with your clients, and be transparent about that so that there's no question about whether you've been biased by the conflict that you may be finding yourself in. And again, this perception piece is often hard to pin down, but it's very important to yourself as a professional and as a member of our profession to be transparent on where these potential conflicts are arising, or even just the potential for that perception can be damaging. So keep that in mind and judge yourself accordingly on these kind of things that arise. So with that, I'll hand it back over to Eric.
Yeah, thanks for that, James. So you're aware, or I think most members are aware, that we're reviewing our code right now, Code of Ethics and Code of Professional Conduct. Pardon me, I'm just getting over a bit of a cold here. We sent out a survey a number of months ago to which a number of members responded, commenting on a number of aspects of our code. And one of the things that came back was concerns expressed by a number of members about the section in our code that deals with dishonorable conduct. And that's a quote that you see on the screen there. And I think what was bothering people was private life. And perhaps it leaves the impression that the Institute is interested in somehow people's private lives, which it is not. The language you see there is not unusual in codes of professional conduct. The lawyers and architects, both of which are regulated professions, have very similar language in their bylaws. So it's in ours. It'll stay if we become a regulated profession. And that's a big if, but if we do, that language will continue on. So on that, the lawyers provide some guidance to their members through the society on this. And what they say, and I'll quote it, is generally the society will not be concerned with the purely private or extra professional activities of a lawyer that do not bring into question the lawyer's professional integrity. So I think substitute planner for lawyer, and very much the same situation applies here. But it's an important part of our code, and we have used it. And I'm going to give 3 examples of where we've used it. The first was a member who was the executive director of what was then the North Shore Economic Development Commission. This is back in the 1990s, and that commission was jointly funded by the District of West Vancouver, District of North Vancouver, and City of North Vancouver. So there was an audit done, and it revealed that the member had been stealing money from the commission over a period of time. It was actually quite a clever scheme, but it was also totally illegal. So the member was charged and eventually convicted of fraud. This is back in the late 90s, and This was a section of the code that we applied in that situation. We started the investigation. The member chose to resign. That ended the investigation. So that was the first time we'd used it. The second time, which probably a number of you be more familiar with, City of Surrey. And this was over 10 years ago now, where there was a planner who was taking bribes. And they were fired by the city in 2010, charged criminally in 2011, and pled guilty in 2013 to breach of trust. So we started an investigation in that case. Again, one of the sections we quoted was this. These are highly publicized. It was heavily covered in the media. And the member chose not to cooperate, which in itself is a breach of the code. And so they just didn't renew their membership. And so we couldn't continue the investigation. So we put the case on the back burner, and it's still there. If the member were ever to choose to reapply for membership, we would reactivate that case and continue on with the investigation. Probably highly unlikely that the member would do that, but it's always that possibility. And then the third case is the one that was in Planning West, which I don't have to go into in any detail. It was published earlier this year, where amongst other sanctions, the member was suspended for 6 months and required to do a few other things. So that was published. So it's been used 3 times, very serious cases. But I'll point this out. It's basically one serious case like this a decade. If you look at the other professions, if you go online to the lawyers, engineers, architects, and so on, much more frequent this kind of discipline takes place. So I think it speaks well of us, the planning profession, that over 25 plus years, we've only had the occasional case that is this serious. Anyways, move on from that. A lot of interest in what we do. The question was asked, what do we get up to? And so over the last 10 years, we've had 23 formal complaints of alleged professional misconduct, which is only an average of 2 to 3 a year. My sense is it's trending up a little bit, not a lot, but instead of 2 or 3, maybe it's 3 or 4. And I think that's for 2 reasons. Number one, we're a larger profession now. We have more members, so it just logically follows, and maybe more issues arise. Plus, I think the general public in particular is becoming more aware of us as a profession. And we have on our website the complaint process laid out. So this probably triggers some of it as well. So instead of 2 to 3 over the last 10 years, I'm betting it's probably 3 to 4 per year now. But again, not a large number given the size of our membership. So we also, in addition to the formal complaints, and I'll get into that in a little more detail in some upcoming slides, we also get a lot of general inquiries, and those go through staff regarding alleged professional misconduct, but they don't result in a formal complaint. And that's because we will not accept anonymous complaints. And as soon as certain people are told that they will be identified as the complainant and they have to file a formal complaint, they back off. So a lot of general inquiry. Some are innocent. They're not actually out to get a planner. They're just kind of wondering about our code and what it says. In terms of where the complaints come from, over the last 10 years, 15 have come from the public and employers and clients, and 8 have been members complaining about other members. So in terms of where these subject members, we call them, the people who are being complained against, practice, 18 were public sector planners and 5 were private sector planners, which would be predominantly consultants. All right. So the other things we get up to, we meet twice a year formally as a committee. You don't hear much about us, and I'll get into why in a few minutes. We're kind of fly below the radar deliberately. So we do things like we're doing today, which is putting on webinars, sessions, writing articles for Planning West on professional conduct. We provide advice in Planning West on situations as they arise. We do assist staff with general inquiries where required. I think staff's pretty good at figuring those things out, but occasionally staff will come to our chair, who's Alex Taylor, right now, and perhaps inquire of Alex. Reviewing policies and processes, that's what we're doing right now. We're reviewing our code of ethics and professional conduct, and we're updating it. You'll be hearing more about that. And these meetings, we receive updates on developing issues and practices of professional discipline. So on that, the Institute's main lawyer is Thomas Lutz, and this is Thomas's area of expertise. He provides advice, not exclusively, he does other things, but a lot of advice to professional bodies, one of which is AIBC. He's very involved in AIBC. So every time we have a meeting, Thomas comes out and talks about what the latest and greatest is. And obviously, one of the things we're talking about right now is this initiative we have underway as to whether we want to become a regulated profession or not. And if we do, what does that mean for our code of ethics and professional conduct, for our committee, and so on. So now we're going to get in an area that I don't think we've really covered off before. Usually we do these webinars, we end off with the code and leave it at that. But a huge part of our bylaws, it's actually part 13, it's called Professional Conduct and Discipline of Members. It's 14 pages out of a 52-page bylaw. So we have a lot of detail on how we handle complaints. And as well as that, it's also backed up by a comprehensive policy and procedure manual, which we put together a few years ago, that standardizes everything we do. It has templates in it for letters, for reports that we do as case officers, and so on. So we're very carefully guided in how we do things. So we saw in the earlier slide, where do we get our complaints from members of the public, PIBC members themselves, employers and clients, and PIBC itself. In other words, we can be the complainant. And in the case of the Surrey situation that I mentioned earlier, and the North Shore situation, we became aware through the media of those situations, but there was no complainant. So we became the complainant itself. With the members of the public, if you want to dwell on that just for a moment, having handled a number of them, sometimes the complaint is legitimate, but sometimes it's a sense of frustration that a planner's made a recommendation to a council or board to, support a rezoning or an amendment to an OCP or whatever, and the a member or members of the public are upset about that and feel that bad advice was offered by the planner, and so they feel sometimes that they're going to get the planner through us, and sometimes there is something there, but quite often there isn't. But we're sort of viewed as the court of last resort for dealing with some of those things. So in terms of our complaint process, it's founded, as are all complaint processes with other professional bodies, on the concept of natural justice, which is also sometimes called procedural fairness. And the first part of that is all complaints are confidential. And we're very careful about that. When a complaint is received, the only people that are aware of it are the chair of the committee, a couple of staff members, the 2 case officers that are appointed, and sometimes legal counsel if they have to get involved. Plus, obviously, the complainant and the subject member are aware, but we make very clear to all parties that it's being handled in a confidential manner. It's so confidential that the board has no idea of the details of these complaints, nothing. All that Alex, as the chair, who's also a member of the board, does is report out to the board on a regular basis. We have 3 complaints, 2 complaints, 1 complaint, 2 have been resolved, 1 hasn't. That's all the board hears. The board has no details on who the complainants are, who the subject members are. The same even applies to our committee itself. When we meet, We share that we're working on cases. We might provide a little bit of detail, but nothing that would identify the subject member or the complainant. And there's a reason we do that, because all the members of the committee could potentially be called upon to form a review panel, and I'll get into that in a little while. And it's important that they not be tainted with any previous knowledge of what's gone on. So it's a very confidential process. The complaints must be made in writing. The complainant has to be willing to identify themselves. They have to cite the section or sections of the code that, in their opinion, have been violated, and they have to present evidence to support the alleged misconduct. And again, it's alleged. Sometimes the evidence we get is very sparse. So we have to go back to the complainant and ask them to provide more evidence. Sometimes they can, sometimes they can't, but it's not our job to run around manufacturing evidence. We may seek out further evidence based on what we receive. We may wish to talk to other parties or look into other information, but it's not our job to go around manufacturing the case for the complainant. Another important step here is the subject member has right to legal counsel. Some avail themselves of that, and when that happens, then it becomes lawyer to lawyer communication. So their lawyers communicating with our lawyer, which is typically Thomas Lutz, and that obviously slows down the process. But most members choose not to use legal counsel. They usually work through it on their own. So after the complaint's received, Alex will appoint, or whoever the chair is, will appoint 2 case officers. And the first step there is to approach whoever he feels to be appropriate in the circumstances and say, do you recognize this name? Or do you recognize that name? And if the answer is yes, then you're not a case officer because you know something about the people involved. I mean, you may have heard their name before, but if you have any sort of a contact with them on a regular basis, maybe you work with them, or maybe you're a consultant, you've consulted to that local government in the past, it's probably not appropriate to become a case officer. So we got the 2 case officers who were appointed. As letters sent to the complainant acknowledging receipt of complaint and appointment of the case officers, and emphasizing that it's a confidential process. That works well when the complainant is a member, because we can control them. So we say to the member, the complainant, this is a confidential process. You're not to share this with anybody. When it's a member of the public, it's a different situation. We have no control over them. So we emphasize it's meant to be a confidential process, but there's nothing that could potentially stop a member of the public from running around announcing that, there's been this complaint laid against a member and there's an investigation underway. And when there's, where there's smoke, there's fire. Actually, surprisingly, it's very rare we have a situation, even when it's a member of the public, they tend to respect the confidentiality of the process. Letters sent to the subject member, same thing, notifying them of the complaint, providing all the documentation. Everything's been submitted by the complainant is turned over to the subject member. And the subject member is typically given 30 days or so to respond. If they need more time for whatever the reason, that's okay. We give it to them. So once we get the response back, we may have everything we need. It's kind of interesting in these cases when you read the complaint. Obviously, the complainant's trying to present the case that they want to make, and you kind of read it, and sometimes like, wow, that's pretty serious. And then when you actually get the response from the other side, it changes the way you're perceiving things. So when we get the information, we may go, okay, that's fine. We've got everything we need. We can reach a conclusion based on that, which would be finding of no professional misconduct and our rationale for it. That's written up in a report that goes to the committee chair. Or we may find breaches of one or more sections of the code by the subject member, in which case we have to explain why we've come to those conclusions. If there's no misconduct, both parties are notified in writing. If there is a finding of misconduct, then we have to consider what the discipline that we're proposing should be, which we call consent discipline. If there's any lawyers in on this webinar today, they will recognize this list because it comes from the Law Society. And these are the factors that we consider in deciding what the appropriate discipline should be. And you can read them for yourself here. I'm not going to go through them all in great detail. Certainly this was a consideration in the case we published earlier this year. The prior discipline, we don't know at the time. When we're going through the process, we are not told, nor is it appropriate that we be told that perhaps the members had prior discipline against them, because that would potentially bias the process. Pardon me. We only ask about that if we decide there has been professional misconduct. We will then approach staff and ask, is there anything in the file in terms of prior discipline? And as far as I'm aware, there has never been a repeat offender. Everything we dealt with, there's been no prior discipline of the member. I got one more slide here. Oh, nope, gonna go back for a sec. So with the consent discipline, we'll propose what we think is appropriate to the subject member. There's no negotiation on it. What we feel the discipline should be is what it is. If the member does not agree, there's a whole separate process, which I'm not going into now, that includes a formal hearing. And that process has rarely been used. In my 25 plus years on the committee, I've never been involved in one. So it's not a process that we use very often. So we have 4 case studies here today. I'm going to do a couple. One I would have been happy not to do, but I was voted to do it. And various of us will speak to each of these case studies. So the first is AI. Second is who's your professional duty to, conflict of interest, and peer review. We got lots of case studies. We could put a dozen up here, but obviously we don't have the time. Plus we want to leave lots of time at the end to entertain questions from members. So I want to give credit to Chi-Chi for the first one, which is not actually a case study because we have not had a complaint involving AI to date, but it's becoming talked about a lot more. And we thought it was appropriate that we provide some advice to our members on the rise of AI. And it's not an area that I particularly knowledgeable in, but I've become quite fascinated with it for academic reasons and for consulting reasons. And I know more of our members are very actively engaged in AI. I've known over the last couple of years, the city of Kelowna, for example, was an early adopter of its intelligent city strategy, which includes using AI for processing certain types of applications and permits. And I know more of you who are in local government are starting to adopt it as well. So it's a very hot topic right now. So in terms of AI and researching it recently, I was reminded there's an old saying in physics that nature abhors a vacuum. And I've concluded that AI equally abhors a vacuum. And when it doesn't know, it tries to be helpful by making stuff up. And so there's a couple of recent high-profile cases or examples. I'm sure a number of you have heard of them. The first was consulting firm Deloitte, which is one of the largest accounting and consulting firms in the world. They prepared a report for the Australian government, and it was discovered by an academic that was reviewing the report that it included a bunch of AI-generated content with serious errors. And apparently in the AI world, it's referred to as AI hallucinations. So this report had a number of hallucinations in it. Great embarrassment for Deloitte. And, they argued and that while there were quotes that were not correct and other things were wrong with the report, that none of it changed their bottom line conclusions and recommendations. And that may well be the case, but it's still an embarrassment. And I want to emphasize Deloitte's not alone. They got, nailed on this one, but they're far from the only ones who got caught up in AI and made some errors in reports. So I think we need to be careful as consultants, in particular, when we're producing reports, that we're confident in what we're producing. There's also a case where a lawyer was reprimanded by a BC Supreme Court judge. I think it was about 2 years ago. And again, the lawyers on this call would be aware of that, for citing fake cases invented by ChatGPT. And so the BC Supreme Court judge who reprimanded the lawyer said, as this case is unfortunately made clear, generative AI is still no substitute for the professional expertise that the justice system requires of lawyers. Competence in the selection and use of any technology tools, including those powered by AI, is critical. So we can substitute in place of lawyers, we can substitute ourselves in there. I think that's the end of the.
I guess thanks, Eric. Just before we move on, I just learned what AI hallucinations meant. So.
Oh, there you are.
And then just to add to that, so I know like a lot of firms are probably kind of updating their policy manual. So we're actually doing one specifically to AI. And then we do have some kind of responsibilities of the employee. You know, we do encourage people to use AI tools because they are quite efficient and effective. But some of the kind of responsibilities of the employee, you kind of touched upon, Eric. So like human review at the end of the day is always mandatory. You have to like be able to think for yourself, know what content is going out there. AI is just a starting point, and to always to make sure to fact checked and do your due diligence and take accountability for the work that you are producing for your clients to avoid instances like the two that you touched upon.
Yeah, thank you for adding that, Chi-Chi. This was the Law Society guidance to its members after that case with the lawyer. And I've noticed now in more reports that it's noted that ChatGPT was used. I was in a meeting a couple of days ago where an engineer was presenting something, and the bottom of each slide had ChatGPT was used. So as you see here with the Law Society, they're suggesting, and I think the same would apply in our case, that when you're using this technology, there's nothing wrong with it, but you should be acknowledging that you're using it. And with that, I'm turning it over to
me.
James.
No, to me.
Oh, pardon me.
All good. So those who may know about Pooni Group, so we are a private planning, consulting, and communications firm. We get engaged to do a lot of public engagement, so hosting open houses for clients and whatnot. And, you know, our clients are usually private landowners, developers, and we host community engagement events and, you know, pass on that feedback to municipal staff as part of a rezoning process. So this case study is, you know, kind of titled, who is your professional duty to? As we mentioned earlier, there's the public interest, the client, your employee, and to the profession itself. So this case study is something that we've faced in our firm before in the past. So you are a planner working for a planning and communications firm, and you've been hired to lead a public engagement process on a controversial project. The client is relying on positive community feedback to justify the additional height and density of their proposal. During the open house, the feedback is quite negative, and the client is pressuring you to draft a summary report, which will be submitted to the city in a way that downplays the negativity and because it would jeopardize the project. So how should you draft that report? Who is your duty to? Is it to your client who is paying your bills, your invoices, or is it to kind of the public interest as a whole? So I don't know, Eric and James, if you want to jump in and have some thoughts, but I can also provide kind of the guidance on that piece as well.
No, please continue, Chi-Chi.
Yeah, so, you know, in our role as a private sector planner, at the end of the day, it is our clients who is paying the bill and our invoices. But overall, you know, as a profession, as a registered professional planner, the duty is still to that public interest, like, as opposed to an individual kind of interest. So there is always a duty to report the feedback accurately and truthfully. Oftentimes, these summary reports are part of the public record. They are part of that rezoning process, and freedom of information, or as part of that process, they can be made public. If the findings are, inflated or not reported truthfully, it can definitely degrade that public trust. As a consultant, with our duty as part of our duty is to our client, the approach would be to help them understand the concerns of the public, because they could be very valid concerns, and see how a proposal can be tweaked in a way to address those key concerns. This also puts the proposal in a position, the best way to succeed in terms of getting approval, because you still have to go through a public process and a political process to get approval. So you want that project to be positioned in the best way possible. And that includes taking in constructive public feedback.
And Chi-Chi, maybe I could add a comment to that. I completely agree. I think the value that planners bring to the work that we do is the so what piece. Gathering public input is data and it's factual, but it's what you do with it and how it's properly shared is where we add the most value. And your point's a really important one. It's what do you do with the information you have, and how do you make the project better for your client, for the community, for future generations as well, is what really gives us the value that we bring.
Yeah, for sure. And we do have clients who come to us at the 11th hour, and it's like checking a box. I need to do an open house in order to get to council. But our advice to our clients is always to engage early and often. So if there are changes that need to be made, you're doing it early on and not before you have to hit council. So there's a bit of a strategy to kind of how we approach engagement, but definitely, James, your point is correct. Like, our role is to advise and look at the bigger picture. And if there are changes that need to be made in order to position a project, in a better response to the public interest, that's our duty to do that. Even if it's our client may not always want to hear that advice, but it's better for the project and the profession as a whole. Case study 3, Eric? James? Which one was?
I think it's Eric.
That's me. I think I jumped over. There we are. So I don't know if John Style is on the call today or not. I hope he is. John would recognize this case study. We've used it for years. We used to call it the gift. We've changed it slightly here. And I want to acknowledge John's important role with the Professional Conduct Review Committee. John was one of the original members of the committee along with me. And in the early days of the committee, we were the only 2 case officers. So John handled some of the cases, I handled some of the cases, and occasionally John and I would work on them together. But over the years, John's provided a lot of valuable support to the committee, helping us update and fine-tune our code of professional conduct and our discipline review process. And John just stepped down from the committee last year, but he's had a tremendous role in supporting that committee over the last couple of decades. So John, if you are on the call, thank you. So conflict of interest, where's the line? And actually we've had some questions we got prior to the webinar today are covered off in here. Everything you see in here is a real situation, not that it led to discipline or even complaints, but just situations we've come across, talked to planners about. So where's the line? First of all, this situation here, planners offer tickets to an event by a developer. Thank you for the work they've been doing on an application. Should the planner accept the tickets? I think the answer is pretty clear. No, that would be a conflict of interest and should decline the tickets. However, the developer then suggests that the planner purchase the tickets at face value. So there's no conflict should the planner accept. What I'm going to offer is just my opinions. This, as you'll see in a few minutes, is a very gray area. There's no black and white to a lot of this. In my view, the planner still should not accept because it creates a transactional relationship between the planner and the developer. And our job is to be arm's length, to be independent and objective in what we do. And even if there's no ill intent, and there probably wouldn't be, it's still kind of questionable. So I would suggest the planner still should not accept, but others may feel different, and that's fine. Other situations for the municipal planner, and this is pretty common, developer wants to buy the planner lunch to discuss their application. Should the planner do that? Some do, some don't. Some agree to meet for lunch, but they want to split the bill. Okay, that's fine. One that apparently is quite topical right now, we got to ask about it, is the gift baskets to the office. If any of you are in a municipal planning department right now, I'd imagine the gift baskets are starting to arrive and will be over the next few weeks. And, you know, some of them are addressed to individual planners. Some are just to the office in general. You can't really stop them. They're just going to keep arriving. What do you do about it? And I imagine some of my friends at the City of Coquitlam are on this call. I don't know if they still do it or not. They used to. And if they are, maybe one of you could confirm that in chat. But what they do is all these gift baskets are received. They sell raffle tickets. And so people buy raffle tickets, the staff, and then they raffle off the gift baskets. And the winners get a gift basket. And all the money that's collected from the raffle is then contributed to a local charity. So it's sort of like a win-win. So I thought that was quite a creative solution that at least the City of Coquitlam, that's how they deal with it. Other common situations, invitations by consulting firms, be it planners, engineers, you know, whoever that do work for the municipality, inviting staff, including planning staff, to summer parties, Christmas parties, be what it may, should a planner accept. And I think that's really just an individual decision as to whether they feel comfortable doing that or not. This last one, again, this is a real situation. Occasional developer invites council members, senior staff out to golf games, dinner, things like that. Should the planner accept? And I remember talking to a planner about this because they weren't comfortable about it. But if they said they weren't going, then they'd be asked why, you know, probably the city manager, whoever, and it would be, well, I perceive that as a conflict of interest and I don't think it's appropriate. So by extension, that's kind of implying that anybody from the municipality who did agree to go is in a non-ethical situation. So that's not very comfortable. Others simply agree to go. So again, it's not a matter of right or wrong. But I'd like to draw everybody's attention to AICP's Code of Ethics, our colleagues south of the border who have provided advice to their members on this issue, and they take a pretty hard line on it. They say planners should not accept or seek gifts under circumstances where it could be reasonably inferred that the gift was intended to influence their objectivity. So it's really up to the planner to determine whether that can be reasonably inferred or not. Their advice is to provide any perception of impropriety. It is best to decline any gift or favor, no matter how small, especially if it is being offered because of one's job. And so their guidance to members is be transparent. If you're concerned about offending someone, just be direct and explain you cannot accept the gift, citing ethical guidelines. So any of you who are feeling uncomfortable about it, feel free to blame PIBC for that. And I'm going to turn it over now to
me.
To James. Okay, thank you.
Before we move on, Eric, just a last thought on that piece. I mentioned earlier on about optics and the AICP code that you quoted was talking about circumstances being reasonably inferred. I think the language was. It's that optic piece again, the perception. So it can be completely innocent. You could be close colleagues with a developer friend who has an application in at the municipality you're working at, but it's the perception of whether a council member sees you having lunch with this person or a member of the public. So it's not to say that you shouldn't do your socializing on your own time, but just be aware of those perceptions. And these situations will come up many times over your career. So there's a lot of judgment that comes into play with these kind of things, and there's no right or wrong answer, as Eric pointed out. But you just being conscious of the perception of others and the transparency piece, I think, are key takeaways there.
I agree with James. Just really quickly, I think there's also value in building good relationships with whether it's municipal colleagues or other colleagues kind of in that profession. So I don't think there's anything wrong with getting together and socializing, but yes, it's the perception. And if you feel like you don't want to do it in a neighborhood where the residents are keeping an eye on everything, or in certain circumstances, but it's also good to keep in mind that it is important to build those relationships with your colleagues on the municipal side and elsewhere.
On that, I'm just looking at something that I think someone from the city of North Vancouver put into chat, which is interesting, which is I'm interested in the tension between municipal conflict of interest rules and PIBC rules. I usually check with my leadership if I have concerns regarding municipal expectations. Yeah, an important point, a number of municipalities do require staff to sign conflict of interest agreements that very clearly spell out what's considered appropriate and not appropriate in the case of that municipality. I'm not aware of any tensions per se. Perhaps there are, and I'm just not aware of them. If anything, I would suspect some of the municipality conflict of interest guidelines or requirements are much more strict. They're very precise, I would think. Ours are a little more open, but I'm not sure there'd be tension per se. But if anybody can point out where there is some, happy to see that in chat.
Yeah, it's a good point, Eric. I think I'd be surprised if there were conflict. There may be different directions, but of course, we all work for employers, and of course, we have an obligation to those employers if we want to keep our job. So it can get dicey sometimes when you're trying to navigate expectations. Again, I'd be surprised if there was a conflict between expectations from an employer and what PIBC is setting out. But I can understand there could be challenges there.
I guess in those circumstances, just disclose and then see what the direction is. It's like when in doubt, just disclose.
Yeah, and that's a really important point. And I've had staff. I've even disclosed conflicts of interest if you are close friends with somebody who has an application that you're working on, or there's just that perception. There's nothing wrong with doing the work, but disclosing it to your boss is always a good idea. And sometimes you can be excused from working on a particular project or application because of that disclosure, and that's totally fine too. I mean, but being open and honest, I don't want to say is never, but I cannot imagine a circumstance where that's a bad idea.
So if you have too much workload, you can just disclose that you have a conflict.
Yeah, I'm sorry. I think these 150 projects, but I'll do this one that I like. All right, so moving on, I'll take on the last case study, and I'm sure there'll be some questions along these lines that we can dive into a little deeper. But this is a very topical piece that the three of us chatted about as we were pulling this together. If you've been paying attention, there's a private members bill in front of the legislature right now called M216, and it's about the role of professional or qualified professionals and the submission of their work and what the planner's role is. And this is likely more in a public setting around challenging the work of others. And challenge is probably a harsh word, but just questioning the scope and extent of the work and whether that ventures into an ethical or conflict of interest realm. But the example here is you're working for a municipality, a consultant, or some other professional, it doesn't have to be planner, submits a technical report. You're concerned about the scope and depth of that analysis, and maybe they've missed something critical that you're aware of. Do you openly challenge that professional and the completeness of that work? And does that venture into professional misconduct piece concern? Oh, lost my mouse. There we are. So there's nothing wrong with questioning the work of others. I think asking questions is the way we all grow and learn. It's how we learn from others, how we share what we know. There's a respectful way to do this, of course. It serves an important purpose to the public interest, and this comes back to that theme again about us having the scrutiny and making sure we're thorough. All planners, all professionals have different experiences, educations, biases, access to information that others may not have. Working in a municipality, of course, I've worked in the private sector and at different levels throughout my career, but my current role at a municipality, you certainly get familiar with the context that you find yourself in. You know of previous technical studies that have been done. You have a different perspective because maybe you are more connected to technical issues in your home municipality in the context of a particular site that is in question, historical data, cumulative impact data that a consultant may not have. So it's important to have that opportunity to bring these ideas to the table in a respectful way. So I think the key here is not making it personal, like having that conversation that can make a project better for everybody. But again, be transparent and fair. If you have a disagreement, approach it in a professional and respectful way, being curious and learn with an open mind to better understand where the other professional is coming from, but share your experience and inquire about the scope of work that was set out at the beginning, making sure that that was clear and the expectations were clear at the outset. If not, address those. It's always easier to defend a position if it's evidence-based. So opinion can be dangerous, but as professionals, we should always be looking for data. We should always be looking for things that we know to be true. Experience can be true, absolutely, but having that data and evidence to support a position always leads to better outcomes and more professional conversations. So again, just want to leave you with this last thought. At the end of the day, we always have something more to learn. I've been practicing for over 30 years and I learn new things every week. And it's also about being curious and wanting to learn new things and being open to the perspective of others. And the profession's changing, and we can make it better by having those kind of open and transparent conversations. So I don't think this is a conflict of interest, but it's the way that you approach the conversation that will make the difference. The new legislation that's going through the province could lead to some really interesting outcomes, and there's been comments and opinions on both sides of the issue, but I think it's never a bad thing to provide those opportunities to question work, not challenge, but to question the work of others. I don't know, Chi-Chi or Eric, did you want to add anything to that or your thoughts?
Yeah, thanks for that, James. Some good advice there. I think I've been involved over the years in a couple of cases where planners have been retained to do peer reviews of work by other planners. Typically, it's in a situation with small municipalities that have very limited internal resources. So they hire consultants to prepare a neighborhood plan or whatever it may be. And then they get it in draft form and they're not sure, does it cover off all the applicable legislation, regulations? And they're assured it does, but does it really? So they go out and get peer reviews done. And in a couple of cases, there was complaints where the planners who had prepared the original work consulting planners felt that the consultants that had been retained to do the peer review were, crudely put, trying to trash them and embarrass them and, poke holes in what they were doing, maybe under the theory that if they're discredited enough that they wouldn't be doing any more work for the municipality and the other firm could come in. So we've got involved in a couple of those, but I've never, in reviewing them, trying to be objective, I never felt that anybody was trying to deliberately discredit anybody else. That, as you point out, it's doing it in a transparent and fair way and being respectful. I mean, peer reviews in engineering, particularly geotechnical engineering, very, very common because it's such a tricky area. And so they're very commonly done. And I've never seen one where, an engineer was out to try and injure the reputation of another engineer, for example. And I haven't seen that with planners either.
And they shouldn't, because that would be contravene of the code.
Yeah, exactly. You're right. She says right in there, be respectful, be careful. There's this whole thing that's before the pros, right? I don't want to steer it off onto that. I don't know, I guess it's another example of things that the province is thinking of doing with the best of intentions, but probably not particularly well thought through. And I don't know where this is going to go, but that's like a whole other thing. Some of you may have seen yesterday, PIBC had a newsletter that they sent out and included a letter that PIBC has sent to the province and copied many others on it on this issue. So I don't know where this is going, but this if it goes where some think it's going to go, this could have some pretty major implications for not only the planning profession, but many other professions as well. So I think probably proposed with the best of intentions, but absolutely no idea what it practically means.
And just a little bit of a service announcement, PSA, they've extended the comment deadline to January 6th. So if anybody on the call wants to submit comments, you're welcome to do that up until that point. Okay, well, that brings us to the end of our presentation. We're open to responding to questions. I know, Sophie, we had several questions come in advance on request, so we're happy to dive into those, and then but I'll leave it to you to kind of navigate other questions.
Great, thank you, everybody. That was a fascinating discussion, and thank you for reminding us. I'm sure a lot of people kind of knew all the principles you spoke about and in the back of their mind, but to validate them and remind us again, that's great. Let's begin with our first question. What is the difference between ethics and a different prioritization of competing interests that other professionals may consider unethical? Why don't you start us off, Eric?
Yeah, I guess this question could be interpreted a couple of different ways, but I've spent the last few days pondering it since it came in. And in terms of our members, as well as people who are just hardcore, planners, RPPs, we have members who are also architects, landscape architects, engineers, biologists, foresters, and lawyers. And in looking at their bylaws, I'm not seeing, and I've never seen anything in their bylaws that's inherently in conflict with our bylaws, other than, for example, the architects and engineers and lawyers, their bylaws and codes are much, much more prescriptive, much more detailed. But I can't think of anything where what we're expecting of our members is in conflict with members who are also members of these other professions that I just mentioned. If someone has an example of that, please put it into chat. But I don't see any fundamental conflict. And in fact, we all crib from each other. If you read our code and then you go over and you read the engineer's code or architects or whatever, you see literally word for word some of the same sections in there. So we've all sort of learned from each other. So I don't find anything inherently in conflict or competing between our profession and the other professions I just named. But again, if someone has an example, please throw it into chat.
Thank you, Eric. Anybody else? No? Okay.
Maybe just quickly on that, Sophie. I know this. I suspect I know where this question is coming from, or kind of the thought behind it. That part of the reason why I love our profession is you are all about the trade-offs and balancing those inputs from other professions, from the public, from other priorities. So if you have inputs coming in from a geotech to use Eric's example, or a qualified environmental professional, and it may conflict with other inputs you're getting. Part of our job as planners is to balance those and understand those trade-offs and be clear on what those trade-offs are to the decision makers. So it can appear that you're going against the recommendation of an environmental professional or an engineer when these trade-offs are brought forward, but that doesn't necessarily mean it's inherently an ethical question. It's about daylighting the trade-offs and the pros and cons of each, and finding a path forward that is the most realistic and achieves the most positive outcomes. So consensus is not always possible, but finding a path forward through trade-offs is part of what makes our job really interesting.
Thank you, James. Number 2, we've already discussed. So we'll go on to number 3. How do planners balance the responsibility to public interest and the restrictions set by legislation that limits the tools we can legally use to support public interest? And they cite the example of community amenity contributions. So for that one, why don't we go back to James?
Sure. Yeah, I can start us off. I'm not sure about the example of CACs and what that thought process is, but we are a very regulated profession, and we have rules that we have to follow. We have structures that we have to follow, and it's inevitable that we have to live within those guardrails. But we have to do the best we can to advance the objectives of our code of ethics and our professional conduct, to represent the public interest within those restrictions. And if you're working at a municipality, you have further restrictions. You have bylaws and regulations and policies. You do the best you can to navigate, but that's what makes the profession interesting. I don't see there being a conflict there. It just means sometimes you have to find creative ways to still represent the public interest and advance what's in the best interest of the publics, however you define those, and within the restrictions you have and with the tools that you have available.
Okay, thank you. Would anybody else like to add anything?
Yeah, well, a couple things. I'm seeing that there's just we just posted something here. Lawyers can't report planners in breach because the duty of confidentiality and loyalty to the client. Alas, it dies with me unless I breach my legal duty. So we're not hoping for that, Louis. Yeah and no. It's dangerous to argue with a lawyer, but lawyers are obligated in their own code. If they become aware of a lawyer acting unethically, they need to report it. And I don't see why there's any reason why a lawyer who's also a planner can't report, as long as they're not a client relationship. I mean, I wouldn't see why, if a planner who's a lawyer sees another planner acting unethically, but there's no relationship, like they don't work for the municipality that the lawyer's advising, I see no reason why they couldn't report them. I mean, the Law Society is very clear on that. It's right in there that if another lawyer's acting unethically, you do have an obligation. And in fact, a lawyer who's charged with a criminal offense is required to immediately, regardless of what the criminal offense is, to report it to the Law Society so they can decide what they want to do. Now, on this, and I don't know if it was in this or it's come up recently. I guess it was part of the survey we did. There's a discomfort by some members, and I get it, with the section of our code that says you have an obligation to report what you believe is professional misconduct by another member. And I think that needs to be put into context. We're really, I don't think, not interested in a complaint about a planner accepting a Christmas gift basket. But, and I think there's other situations arise where our advice is, if you think the planner is doing something that may be inappropriate, but kind of a gray area, go talk to them. Don't use us as kind of the referee on those kind of things. But I think there would be, obviously, using the Siri example or some of these others, I mean, if a member became aware of something that egregious, it would not be a matter of going and talking to the planner in question and suggesting accepting bribes is not appropriate. Absolutely, you would have to report that.
Okay, any other comments? Thank you, Louis, for starting the discussion on that one. I think that's Louis Carvello, but I'm not sure. Let's go on to number 4. Is it unethical or unprofessional for a local government planner to refuse to provide all application submission material in their staff report to their board or council as information for them to rely on to make an informed decision? I would like to go to Chi-Chi to start us off.
Yeah, I mean, I guess it depends kind of on the context. Like in staff reports, and I'm sure many of us have read many staff reports, there's always a summary of, you know, the technical studies and reports and findings that were part of the process. Very rarely is the entire technical report attached, or the council agendas would be thousands of pages long and no councillor wants to read that. So I guess the word that I'm kind of caught up on is refuse. I've seen in council meetings where they would ask staff, like, hey, was let's say a transportation management report done for this? And staff would say, yes, happy to provide it to council for further information. That report is not included in the staff report, so I wouldn't say that's unethical or unprofessional. If I can't imagine this happening, but I can't imagine like a planner being like, yes, we have it, but we're not going to provide it to you. If that was the case, then, you know, it is not being transparent, and I wouldn't say it's being unprofessional, but most of the times the entire reports are not in a staff report that goes to council, but it is available to be shared either publicly or with councillors if they do request it.
Great, thank you. Eric, James, anything to add?
Maybe just quickly, sometimes you run into confidentiality that you can't put people's personal address or contact information in a public report. So often it's the safest thing to do is to summarize. And if you get hundreds of comments, you're not going to necessarily expect council to wade through that at a meeting. It's your job to kind of summarize and bring that up to the higher level that Chi-Chi's talking about. And you can say that, you know, the raw comments are available if you want to see them. I have worked in municipalities where they want to see all the comments because they don't trust council's roll up or staff's roll up, but then you end up redacting a whole bunch of information because your privacy officer, if you have one, will be on your case about that.
Yeah, this is an interesting one. I talk to planners about this all the time. So there's two parts to this. One, I'm perhaps reading into that question that a planner is withholding important information, information a council should be aware of. That is a concern if it's meant to deliberately bias council's or board or whoever's view on things. The other part of it, though, is if it's simply that everything to do with everything is not in the report, well, it shouldn't be. But part of that depends on the municipality. And James, I've mentioned to you before out here in Maple Ridge, where I live and James works, I like the planning reports from the Maple Ridge staff. They're short, they're concise, they're to the point. They lay everything out. The information, if council wishes to ask about it, is available. No one's trying to hide it, but it's not, you know, endless attachments to reports. But you have other municipalities where, at the direction of the council, they want everything. And I can name a municipality, I'm not going to, where it was demanded that even things like geotechnical reports were attached to the staff reports. You get a planning report with 30 attachments, it's hundreds of pages long. No one's reading that. How could anybody in council be expected to read all of that or even understand it? So part of it is really what the policies are, the particular local government, as to how much they think it's important that their council receive.
Okay, thank you. We've covered number 5 in the presentation already. So on to number 6. How can someone contribute to nonprofit organizations in the city where they live and work while also serving as a professional planner for that municipality. James, since you're working in the public sector, why don't you start us off?
Sure. Yeah. I think the short answer on this one is sure. Absolutely. We all have our own kind of personal opinions and things that contribute to other organizations, contribute our knowledge. There's nothing wrong with doing your own things on your own time and using your expertise to help advance that. Where it starts to cross over is the provision of confidential information that you might have access to because you're working for the municipality. Of course, you can't do that. Or trying to advance a case or application that you're working on, or be an advocate for that organization in front of the council. So just, again, it's the optics piece again, and it crosses over at some point there where it's not appropriate. And you should be very clear you are working for an organization that has an interest or is advancing something in the municipality. You disclose it, and then you don't work on that file or come anywhere near that file as it's being processed by the city. And again, if you're transparent on that, nobody's going to fault you for being involved. But it can be a dangerous slope when you become an advocate, and that word comes up from time to time in our profession, that we're not to be advocates for particular issue areas or developments or things like that. But sharing your knowledge and being involved in organizations that can advance, the public interest or social good on your own time, I think that's a good thing.
Okay, thank you. Number 7, we've covered. And number 8, in general, who should planners speak to in confidence if there are concerns about ethics and professional conduct? Eric?
Yeah, good question. So the person you should contact at PIBC is Matthew Walsh. I just joined the organization about a year ago. He's the Administrative and Governance Coordinator for PIBC. And Matthew's one who now supports, and does a tremendous job of it, supports our committee. And we can be pretty demanding at times. So Matthew's the one to contact. There's 1 or 2 senior members of the committee that Matthew will then, on a confidential basis, refer the member through to have a discussion.
Okay, and I've added his Matthew's email address in the chat.
Maybe, Sophie, before we move on, I see Nicole's question. She just wants to get some clarification around the gifts.
Yeah.
Would it be fair to say the safest approach is for planners to decline all gifts?
Yeah, I mean, that is absolutely the safest approach. And I think it's pretty clear that's what AICP is suggesting. This gets me thinking, as we run out of projects, Chi-Chi and James, on the professional conduct committee, now that we've got certain things out of the way, I think we should be putting together more guidance for our members, just as the ICP does on these very issues. We should not have to be seeking out guidance from AICP. We can crib from them, but we should be putting together our own guidance on our, as part of updating our code, where we're going to be changing certain wording, adding sections, deleting sections. I think once we've gone through that and the new bylaws approved by the Institute, that we should be then writing up some guidance that further elaborates on what we mean by each of these things.
Yeah, I agree. Like my time in the public sector was a while ago. I remember at that time, it was kind of like, oh, if the gift is under like $10, like that's not going to sway your professional judgment on a project or a client. Like if somebody wants to like drop off like a small box of chocolates. But if it's something that's more than that, then you kind of have to share it with the department. So I know, I think times have changed from them. I think to be safe, if don't accept anything, period. But there might be some thinking around, like if it's a small gift, like like a muffin or something. I don't see that as being an issue if you want to accept that from a like if you want to give that or accept that. but it is still a gray area for sure. Obviously, if someone's giving you hockey tickets, Paul
Right.
want to say no.
How about World Cup tickets?
Yes. But also, have some self-respect. If you can be bought for a muffin, like, come on, it's making us all look bad. That doesn't help.
Really good muffin.
Well, it could be a good muffin, yeah. I think this is another one where you seek guidance from your employer, because every municipality probably has some kind of policy about the acceptance of gifts and what is appropriate. And if they don't, then when in doubt, don't do it. But our practice here at the city is I think Eric touched on this. When you get a basket, it's hard to return chocolates, but if everybody can enjoy it, there's a lot of people in the organization that don't get the appreciation that they deserve, and to allow your admin staff or your support staff to have a little bit of a treat is not a bad thing. If it's just like a shared thing, then optically it looks a lot better. But again, it's the appearance. So yes, if you get hockey tickets or somebody gives you a bottle of something and you're walking out in the parking lot with it, that does not look good for anybody, your employer, yourself, or profession.
A few years ago, we had a planner, the head planner from Oregon, do a presentation for us. And to thank him, I sent him down a Starbucks gift card. And when he received it, he sent me an email and said, "Thank you. I'm taking my staff out for coffee."
Oh, nice.
So he shared it. So I thought that was a great way to handle the situation.
Yeah,
I think a lot of times the intent of the gift is to say thank you. It's not to sway or bribe anybody. It's just kind of like, usually like with our firm, at the end of the year, we send out thank you gifts. It's been a year. Thank you for working with us. That's the intent. It's not meant to, bribe anybody.
But again, it's about the public perception.
Yeah.
John Style used to have a great slide on this when he did this stuff. His perception is reality. And you really do have to think about some of this stuff from the perspective is if you were seen doing some of these things, how might it be perceived? And it's done in all innocence. There's no bad intent, but how is it perceived? And we seem to be, unfortunately, perhaps in a society now where just about anything you do is on Facebook within an hour and twisted out of shape. So I think even more now than ever, we have to be so cautious about what we do because of the possibility of misinterpretation.
And these things tend to be sticky. They stay with you for a very long time. So if you are labeled as somebody that accepts these kind of things, it's really hard to shake that. Even if it's not true, it's really hard to do that. So I had a mentor years ago that always asked the question, "Is it worth my career?" So he would refuse everything, and it was just safe, right? It's easier to say no and move on.
Okay. So we had a couple of more questions that were submitted after we received the ones that you can see on your screen, and we do have a few more minutes. The one question, I see it again, Eric Wang, can city planning manager comment that QEP hired by the applicant as developer QEP is professional misconduct? Chi-Chi, would you like to handle that?
Yeah, I think it needs a bit more kind of context. If it's just being referred to, this is the applicant's biologist, this is the applicant's architect, I think that's fine. But if the implication is like, oh, this is the developer's biologist, don't kind of listen to the recommendations that they're providing, I would think that is quite problematic because at the end of the day, they're also a professional and they have a framework and a code that they are probably abiding by as well. So to make that implication, I would say is unprofessional, but just to acknowledge this is the developer's, or this is the applicant's biologist in a meeting, that's fine in my view. I know Eric and James, if you have any thoughts.
I mean, that's the way the process works, is that an applicant, as part of a rezoning application or a development permit application or whatever, is required to retain professionals to do a whole range of studies. The local government doesn't have the money to go out and retain people to do all those things. So there has to be, within reason, some faith in what you're receiving is correct. But, any of us who have been in local government planning on the development planning side, some of the stuff that comes in is not very good, quite honestly. But sometimes it's not the fault of the developer or the applicant. They don't know. They're just assuming that what they're submitting is correct. But I think we would all find situations where there's no bad intent by a professional in what they submitted. It just doesn't fully meet or comply with the city's bylaws or regulations or whatever. So we can't just rely on those reports that are submitted at face value. But I mean, that's the way the game works, that these reports are prepared and paid for by landowners and developers. I don't see any way around it.
So Eric Wang is saying it was the latter. So it sounds like this manager was implying that, I guess, the recommendations or the findings of the biologist was, I guess, biased towards, I'm just kind of trying to piece it together here, that it was biased towards the developer because they were engaged by the developer.
Mm. Yeah, that's James. You see this all the time. Things like environmental. It's not as precise as science as engineering, where everything's formula driven, and you put 6 engineers in a room and give them a problem, they should all probably come up with pretty much the same answer. That much like ourselves as planners, biology, there's a bit of subjectivity in there, and what one biologist may think is perfectly appropriate, another may not. So that I found over time, James, I probably you as well. Anything to do with the environment tends to be a bit of a tricky area.
Yeah, and it can be a lightning rod for the public too, because they can be very sensitive to these kind of issues, and you'll get interest groups and other people that pay very close attention to these things. So again, it is a gray area. You don't want to slag any professional colleague, but to make it clear that this is submitted with the application is perfectly reasonable, like Chi said. But you don't have to agree with it either. And that goes back to the case study I talked about a few minutes back, that, you can say, in staff's opinion, this is the situation, but here it is in all its transparency, because you also have a job as a municipal staff person to provide recommendations on what you think is the best way forward and be transparent. It's never a bad thing to show evidence that might counter your recommendation. I think that also demonstrates that you've looked at all sides of it, and on balance, this is your recommendation. So you shouldn't filter out things that may not align with what you're trying to recommend. In the same token, you have to show that you've considered all these things, and your rationale has to show that you arrived at a recommendation based on these factors.
Mm-hmm.
But I guess, James, what if the manager is just saying it to, discredit the consultant, or to say maybe they don't want to see a project go forward, and then they're saying, well, it's actually this, but then the biologist says this, but they're hired by the developer, so of course they're going to report in favor of their client. I think that is a bit more, it's harder to, I guess, define that's the exact intent, but that would be a bit more problematic than just saying we disagree with your findings and this is the reasons for why.
Yeah,
I see someone said lots of subjectivity in engineering too. Fair comment.
Ryan. Thank you, Ryan.
Yeah.
We always rely on your wisdom.
Ryan's
a regular.
Yeah, I've always joked that the job of engineers is to crush the dreams of planners. Pointing out what we want won't work. But anyway.
Okay, so it's 1:30. If people can stay on another minute or two, we have a final question. Do municipal planners have a professional responsibility to refuse the implementation of planning policies or other actions directed by council if they believe such instructions conflict with responsible planning? James, would you like to comment on that?
Sure. I know we're kind of up against the time, but just quickly, if you are working for a municipality or even as a consultant, you have decision makers that you report to. So if you find yourself in a situation where council, as a decision maker, makes a decision, that's the process. Planners are not decision makers, we're advisors. If council gives instructions, then as an employee of the municipality, you're obligated to advance them. You don't have to agree with it. But the key difference is when you are putting forward a recommendation or you've done an analysis and your name's associated with it, then it's different. Then you have to be confident that that is what you believe in and stand behind. But when council says, you know what, thank you for your input, but we're going to do this other thing that you said was a bad idea, you have to accept it. You don't have to like it, but you have to accept it and move on and advance it, because that's the direction you're given and that's your job. And this is the balance between you're getting paid to do a job, but you're also a professional. So you have to make those challenging decisions sometimes of where they start to intersect with your ethics. But responding to the direction of a decision maker is not an ethical problem on its own.
Okay, great, thank you. We will now go to the final slide. I forgot to mention earlier that this webinar is being recorded, and you're able to access the recording on YouTube after a few days. So if you came late or well, if you jumped off early, you're not hearing this, but if you came late, then you can always go to YouTube and rewatch the webinar, which is not a bad idea. So thank you again to all of our presenters, Chi Kai, Eric Vance, and James Stiver. Very fascinating discussion today. Everybody watching can log 1.5 CPL units for watching. And then in terms of upcoming events, we do have another free webinar. It's a PLN webinar on standardizing housing designs and rules. So you could go to our website and sign on for that one. In January, we have our annual planning outlook, and we've secured Lisa Helps from the BC Housing to talk about the provincial government's housing plan as one of our speakers. And then June 2nd to the 5th, the 2026 PIBC Annual Conference, Bold Plans Local Action in Penticton, BC. The committee is hard at work, and we hope to see everyone there. We do have opportunity for sponsorship. So if you're looking to sponsor something, I think it's already on our website, so you can go there to find the link. Thank you again to our speakers, and thank you to everybody for watching. We'll call it a webinar.
Thank you.
Bye.
Thank you.